Good morning. Today is October 5th, 2023. It's approximately 9:30 a.m. This is the matter of the application Z0286-23, an application by Christopher Weiberg for a home occupation conditional use permit. My name is Carl Cox. I'm a private attorney appointed by the Clackamas County Board of Commissioners as land use hearings officer. I have a couple of important things to state for the record. First, this is a quasi-judicial land use hearing, which means two important things for those participating in this hearing. First, all of the criteria that can be used in reaching a decision have been identified in the staff report. Testimony, arguments, and evidence must be directed towards the criteria identified in the staff report or other relevant criteria found in the comprehensive plan or other land use regulation that the person believes applies to the decision. Accordingly, please direct your testimony to a relevant approval criterion. Second, failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and the parties an opportunity to respond to the issue may preclude appeal to the Oregon Land Use Board of Appeals on that issue. Failure of the applicant to raise constitutional or other issues relating to proposed conditions of approval with sufficient specificity to allow the local government or its designee to respond to the issue precludes an action for damages in circuit court. Once final, this decision may be appealed to the Oregon Land Use Board of Appeals. I have a couple more statements to make. First, the county is making a record. That record is available through the county. And in a moment, I will ask the county to provide an explanation concerning participation in this hearing via the Zoom platform. I want to talk first. I have received ex parte contact in this matter. No one contacted me prior to this decision, this hearing concerning this land use decision about this particular land use hearing decision to try to persuade me concerning a fact or issue present as far as my review of the evidence presented in this hearing. I did download and receive the exhibits that were provided, including the staff report and related items. However, I have prior knowledge of some of the underlying issues here. I also held a hearing on July 18, 2023. I believe Mr. Weiberg and Ms. Mathenia remember me in a related a code compliance matter with several issues related to the property and somewhat related to this hearing, and that in that code compliance hearing, I ordered that the owner of the property timely follow up with completing this land use hearing application process. So before we go any further with this, I'd like to ask if there are any objections to my conducting this hearing based on my disclosure of the ex parte contact that I just made. Oh, I will state that I have also considered issues of bias and conflict of interest, having determined that I do not have any conflict of interest in this matter. And I've carefully considered my involvement in this hearing, my involvement in the code enforcement hearing that preceded this hearing, and have determined that I do not have any bias in this matter. Okay.
No objection from me.
No objections. How about the county?
No objections from staff. I would note that you also reached out to me about procedures.
I did.
In
contact you about
cases such as this regarding previous code enforcement cases.
You're absolutely correct. I asked if there was any procedure for this, and determined that it was just my procedure for disclosing ex parte contact, as I always do. All right, thank you. At this time, I'm going to ask that the county provide an explanation concerning participation in this hearing via the Zoom platform.
So this public hearing will be conducted virtually using the Zoom platform. Panelists for today's hearing, which include the hearings officer, county staff, and the applicant and applicant representative attorney, have both audio and video capability. Audience members who have joined the meeting will have their mics muted unless they wish to testify, in which case they will be called upon to do so by the county staff moderator, Darcy Reinhardt. Audience members' videos will not be turned on at any time. Today's hearing is being recorded as required by law. The county will make every effort to post the recording on the county website later today. There is a designated time during the hearing when it will be open for testimony. The hearings officer will make it clear when this is. If you want to provide testimony, you will utilize the raise hand feature. Attendees on PC and iPad, you have a raise hand button on the Zoom bar. It's either at the top or the bottom of your device, depending on the type of device you have. When the moderator switches you over to provide testimony, your screen will look different for a little while. Primarily, you will see all participants' cameras, not just the one who is speaking. Staff will call upon you when it is time for you to provide your testimony. Be sure to provide your name and mailing address when you begin. Once you have provided your testimony, your mic will be muted and your screen will be returned to normal. If the record is left open at the end of the hearing and you wish to submit additional written testimony, email written testimony to myself, Joy Fields, at jfields@clackamas.us. Or you can mail your written testimony to Clackamas County Planning and Zoning Division, 150 Beaver Creek Road, Oregon City, Oregon, 97045. The staff contact email address is available on the webpage where you found the Zoom link for today's hearing, and testimony must be received by 4 p.m. the day the record closes. This contact information is also in the PowerPoint presentation that I will give at the end of the presentation. So if you need to see it again, it will be available for you there. People who testify and provide their mailing address will receive a copy of the hearings officer written decision. If you do not wish to testify, but would like to receive the decision, you must provide your email and standard mailing address by emailing the staff contact for the application or by entering it in the Zoom chat function during the hearing. With that, that concludes my statements.
Thank you. The order of proceedings will be that I'll ask the county to begin the hearing by presenting the staff report. If the county has a presentation to make that's associated with that, I'll ask that the county submit that as an exhibit to the record after the hearing, followed by an opportunity by the applicant to submit evidence and testimony in support of the application that was submitted. I will then provide an opportunity for members of the general public to provide comments. I may provide opportunities for either the county or the respondents the applicant to ask questions or answer questions that arise during this hearing process. Are there any questions before we begin? No? Okay. I'll ask Ms. Fields to begin. You're muted there.
Yes, I saw that. And so I took a deep breath to start speaking and saw that I was muted. So we are here today for the public hearing for Z0286-23. And this is a home occupation application with exceptions. The applicant proposes to use up to 3,000 square feet of an existing 2-story renovated hay barn with an approximate footprint of 80 feet by 64 feet. And the applicant proposes to use this structure as offices and storage for parts and tools related to a home occupation or a construction business. The applicant requested an exception to section 822-0.04B to allow 15 employees to be in the accessory structure. Additionally, they requested an exception to the square footage. Based on the site of the property is able to be a level 2 home occupation, and a level 2 home occupation limits to the accessory building floor space to 500 square feet, and the applicant is requesting an exception to section 822.04 L1. And pursuant to the exceptions section of the zoning development ordinance 822.05 AC2, the floor space of the accessory building cannot exceed 3,000 square feet.
Let me ask you a question about that. Do you interpret that the entire structure cannot exceed 3,000 square feet, or the available to the home occupation cannot exceed 3,000 square feet?
The available space for the home occupation may not exceed 3,000 square feet. Section 822.04 L1 identifies a way in which an accessory building can be separated using a 7-foot high wall to separate the space used for the home occupation from the other space that may be used for residential purposes by the applicant. And I will talk about that later on in the presentation.
Thank you.
In addition to the 2 exceptions that the applicant specifically requested in the application, there will need to be an exception to 822.04 L2, as well as 822.04 L3. Based on the review of the application, with 15 employees coming to and from the site every day, in addition to deliveries of tools and parts, it is anticipated that staff anticipate that there will be more than 20 vehicle trips per day. If that is incorrect, I hope that the applicant will address that during their time for speaking. In addition,
and I'm sorry to interrupt, but would you provide an explanation concerning how those vehicle trips are counted?
Yes, it counts both directions. So 1 vehicle for an employee will have 2 vehicle trips per day. So they will be coming in and they will be coming out. The level 2 home occupation allows 20 vehicle trips per day. To allow more than 4 vehicles on the property at any time, and potentially more than 1 delivery per day also requires an exception, because those are the limits set for a level 2 home occupation. The site of the proposed home occupation with exceptions is located at the northeast corner of Northeast Airport Road and Northeast Miley Road. It is just south of Wilsonville, and it's on a property zoned RRFF5. Both of these parcels are highlighted because previous staff research indicates that they are combined as one legal lot of record. And therefore, while the home occupation is proposed on the southern portion of the property, staff is considering both properties in concert because of the previous research that indicated they're combined as one legal lot of record. This is an aerial of the site of, I believe it's tax lot 800, that southern one that shows the 1963 residence and the accessory structure. All of the structures that are involved in the home occupation are located on tax lot 800. And they, again, include the house and the accessory structure. The house is only proposed to be the residence of the home occupation operator. It is not anticipated that there's any work related to the home occupation occurring in the dwelling. The dwelling is a 1963 home that was renovated or has a 2023 permit for renovations in existence. The hay barn, located in the southwestern corner of the lot of record, is a 2-story hay barn with an approximate footprint of 80 feet by 64 feet. And there is a well on site that the applicant indicated had sufficient flow for both the residents and the proposed home occupation. There is a driveway that served the house, and there is a concern of a new driveway that was installed further down Northeast Airport Road that will need to be removed to meet the driveway spacing standards pursuant to the comments received by the Transportation and Engineering Division, Exhibit 5. As I mentioned, we are talking about the legal lot of record that is in Township 1, Township 3, Range 1W, Section 25, Tax Lot 800 and 804. These properties are zoned RRFF5. That's a rural residential zone with a 5-acre minimum. The acreage combined in the two parcels are between 18 and 20 acres. I have that range of acreage because the applicant indicated that it was 20 acres and the tax assessment office taxes approximately 18 acres. And so without a final survey of both parcels, the exact acreage is not being presented here. There is a river stream conservation area on the property. It is located on the eastern side of tax lot 800 and goes through the middle of tax lot 804. And based on aerial images, it appears that the proposed home occupation location is more than 450 feet from the stream. So it's outside of any regulated buffer that would require additional land use review. If there is disturbance closer than 100 feet, then land use review may be required. But because of the distance, staff do not anticipate that the river stream conservation area will come into play with this application. The renovations to the barn, they did apply for a building permit. The electronic records didn't indicate that there's a final inspection yet for those renovations. And so if their application is approved for a home occupation with an exception, a change of use building permit as well as a final inspection of previous work will need to occur. Again, there appears to be 2 driveways serving the site, and based on the roadway standards table 2.2-2, one of those driveways will need to be removed because of the driveway spacing standards. Notification for this application went out to 760 property owners. It's a fairly dense area of development because it abuts Wilsonville. And so there are a lot of residences in addition to those directly adjacent to the property across the road in the city of Wilsonville. The Aurora Butteville Barlow Community Planning Organization received notice and provided comments that indicated that the level of activity was not compatible with the surrounding community. They had concerns about the traffic, outdoor storage, space, the amount of space proposed in the accessory structure, and just the overall level of activity, including the 15 employees. The septic and on-site wastewater program went out and did a site evaluation for a system size for a 4-bedroom house and 15 employees, and provided the applicant with guidance related to that. The city of Wilsonville also provided testimony that the proposed use is incompatible with the rural reserve that the property is located within, and is incompatible with the surrounding area, and there are concerns with traffic, sewer, and environmental impacts. As I mentioned, the engineering division provided a memo, it's Exhibit 5, that a development permit will be required for any street frontage and driveway improvements, and that one of the driveways will need to be decommissioned to meet the spacing requirements. So we are here today because a home occupation is an allowed use in the RRFF5 zone. Based on the size of the surrounding parcels, less than the majority of the surrounding parcels are over 2 acres in size, and so based on the location, the site could qualify for a level 2 home occupation. The applicant.
Right. Just a minute, is that correct? I thought it was the other way around. Oh, level 2, you said, not
level 2.
Okay, thank you.
Yes.
Sorry.
To qualify for a level 3, more than 50% of the adjacent properties have to be over 2 acres in size, and staff did not find any evidence to that effect.
I just misheard you when I'm looking at where it says level 3 on the slide, and I heard you say, less than a majority was okay.
And
no.
Thank you for pointing out that typo, Carl. And I will modify that before saving it as an exhibit as a scratch through to indicate that it's a level 2 major home occupation.
Okay.
So thank you. In the application materials, the applicant provided that the operator of the home occupation will be the manager of the property owner. So the property owner is an LLC, and the home operation or operator is the manager of the LLC. The employees proposed for the home occupation include 15. That's more than the number allowed in a level 2 home occupation, thus the exception request. It is based on the application materials, there was no indication that there would be a significant amount of noise from the home occupation. However, testimony received from neighbors indicates that there is a concern about the potential noise from the level of use proposed through this home occupation with exceptions.
I do have a question about that also, and thank you for your patience with my interruptions. I just like to do it as it happens, and here we are on noise. I saw in your staff report that you stated that idling of vehicles is exempt from the noise limits, but that's not how I read that. I read that the noise of vehicles entering and leaving the property in a level 2 home occupation is exempt, but not idling of vehicles.
I will revisit that, and if there needs to be a correction, I will make a correction during the open record period.
Okay.
And I can look at that during the applicant's time for testimony and may be able to address that at that time.
Thank you.
There was no indication that there would be electrical interference, and the storage and outside storage and display is prohibited in the level 2 major home occupation, and the applicant did not indicate that there would be any outdoor storage or display of items related to this home occupation. The applicant did not indicate that there would be any signs related to the home occupation. There is a sign section of the code that would require a sign permit if a sign is proposed. With the acreage of the property being 18 to 20 acres, the applicant indicated there's ample room for parking. And based on the aerial images and the site plan provided, staff would agree that there's on-site parking available for the proposed home occupation. The access is directly off of a public road, and so there's no concern about having access agreements or access easements to access the property because of the direct access. The property is not zoned ag forest or EFU or timber, and so the type of the building is irrelevant to this discussion. Based on the application, it appears that it was previously a hay barn, and the characteristics of the building still appear to be a hay barn, which would be appropriate in the RRFF5 zoning, since agricultural use is an allowed use in that zone. However, because of the zoning, this is not applicable to this particular application. There's no indication that hazardous materials would be part of the home occupation, but as we discussed, it would be a level 2 home occupation based on the size of the surrounding parcels. As mentioned earlier, the applicant is or requested an exception to the number of employees, as well as the building square footage used for the home occupation, and additional exceptions would be required for the traffic and vehicle traffic and number of vehicles related to the home occupation. The proposed use is not a prohibited use. And so we move into the sections of the code that specifically pertain to exceptions. Subsection 822.05A specifically says that the number of exceptions requested can be used to demonstrate compatibility. And the applicant is requesting 2 exceptions, and staff found that at least 4 exceptions would be needed to meet the criteria of the code. That is a lot of exceptions. And because of the high level of intensity from the extra employees, the extra traffic, the extra vehicle parking vehicles on site, there is concern about the compatibility with the rural residential neighborhood. Exceptions are not supposed to disrupt the character of the neighborhood. And there is concern that the traffic would not be compatible with the rural nature of the area. And thus, a traffic study may be appropriate as a conditional use or a condition of approval if you determine that the use meets the criteria, just to verify the proposed traffic and model it to make sure that the traffic would not create a backup on Northeast Airport Road beyond what would be anticipated for the rural residential neighborhood. The applicant did propose screening using landscaping materials, but the site plan did not identify where those plantings would be located, and so additional information on mitigation measures would be appreciated to see if the applicant is mitigating the impacts sufficiently. Staff did not find a potential environmental impact above and beyond what a residential home would have, and so staff does not have concern with potential environmental impacts related to this home occupation. The road improvements, as we mentioned, the transportation and engineering staff indicate that there will be necessary improvements to comply with the driveway separation standards. You asked about 3,000 square feet. And the requirement is that a partition wall, at least 7 feet in height, separate the area used for the home occupation from the area not used for the home occupation. And the schematics provided by the applicant indicate that this separation wall would be very difficult to obtain with the proposed layout. If you look at the entrance to this area that is circled in red, it requires passing through area they're not proposing to use for the home occupation. And so if you put a 7-foot wall here to separate the area used from the area not used, then you would have to get permits to have doors to the exterior of the structure. If you just put a 7-foot wall here, limiting this space from this space, then you would not have access to the area proposed for the home occupation. So in addition, oh, sorry, I thought I put it on the next slide, but it's over on the right-hand side of the slide. In addition, they're proposing some of the second floor to be used for the home occupation. And so closing off the stairs from this primary area would not be possible because they're also proposing use on the second floor. And so there's no way to separate it using a 7-foot wall because of the locations that they're proposing to be used for the home occupation. With the number of exceptions requested, the increase in traffic and vehicles on site, and the inability to use a 7-foot wall separation with the proposed alignment of space, staff are recommending a denial of the home occupation. I know that you mentioned you asked your questions throughout the presentation, and I will take a look at the idling of vehicles while the applicant presents their report and get back to you to answer that question of yours. Do you have any other questions?
No, and thank you for your patience with my asking the questions during your presentation. I know it's a little bit of an interruption, but that's when the subject's on the board.
Correct. So. I think it is completely appropriate. And I will modify this slide as an exhibit, and I will say that I did copy this over from a previous presentation, and I apologize for the incorrect application number. But if you would like to submit testimony by mail, you can mail it to Clackamas County. Please put Z0286-23 as the file number. And you can mail it to 150 Beaver Creek Road, Oregon City, Oregon. And we receive mail Monday through Thursday, 8 to 4 p.m. And our lobby is also open to receive it if you want to deliver it by hand. My email is jfields@clackamas.us. And if you want to submit testimony or request a copy of the decision, please send us an email or mail us a request. With that, I will stop sharing.
Thank you. At this time, I'd like to offer an opportunity for the applicant to submit evidence or testimony and an argument in support of the application in this matter.
Good morning.
Good morning.
First, thank you all for taking the time, and Mr. Cox for our previous hearing. We have appreciated your input. I think to start, we fully recognize the concerns and frustrations of the neighbors. I myself live in inner Northeast Portland, and it's a challenging time to live in Portland, and I would love to get out and live out where you all live. And I completely identify with the joy and peace of living in a rural neighborhood with quiet and tranquility. So I think as additional background, it's important to establish that the property was in a bit of disrepair when the Weibergs purchased the property in 2018. During COVID, their business was abruptly and significantly impacted. And I think that contributed to kind of getting off on the wrong foot. They were trying to keep their business running, trying to work through understandable county backlogs and shutdowns, and really just trying to stay afloat. So I think that is sort of the foundation that led us to where we are here. When I was retained to help resolve some of the compliance issues back in November of 2022, I initially was working with Ted Weiberg, and I won't speak for them directly, but I think Christopher took over shortly thereafter and is quite adept at communicating, concerned about the neighbors' frustrations. I've worked pretty closely with him and with Anthony Ragoni, also at Ohana Group, and they're incredibly communicative and responsive and very involved in this process. So while we understand and the neighbors' frustrations are entirely valid, we are hoping to resolve this amicably and come to some sort of legal collaborative solution. As a threshold matter, I believe that answers would be directed at you, Mr. Cox. The testimony submitted by the Wilsonville Planning Department suggests that this home occupation would require a Goal 14 exception, and that is incorrect. And I raise that only because, if correct, it would thwart the application entirely. So I think at the outset, it's important to establish that there's no exception needed. If the homeowners are not familiar, the LCDC, which is the Land Conservation and Development Commission, is a state agency tasked with establishing goals for growth and development. And local agencies like Clackamas County are then tasked with putting those into action, establishing the local ordinances. So the planning department suggested that Goal 14, which moderates urban development in rural lands, would require an exception to even consider this home occupation application. And that's incorrect. The exceptions are required for an entire change in zoning, for example, bringing urban level services like sewer and water to rural land, running a type of operation that's, say, establishing a residential subdivision in forest or timberland, and that's not what we're seeking here. As Ms. Fields mentioned, this is already an approved accessory use. So in other words, the businesses that Weibergs are seeking to operate is already an allowed use, but it needs to be permitted and it needs to be done within certain guidelines. So I would like to get that on the record, please.
I agree with, I think your assessment. I'll have to look at it closer, but the determination, well, first, there's no request here to change the actual zoning of the property. So the zoning will remain RRFF5. The determination of urban versus rural uses of property involves a number of factors, including the ones you just stated, things like availability of public sewer. We're not talking about that. Availability of public water. I agree that's also a factor here. I would want to go through the analysis myself. I don't just wing it. I think you can appreciate my position there, but I see what you're saying. Please proceed.
Certainly, thank you. I guess next it makes most sense to address, as Ms. Fields did, the individual factors in 822.04, factors for consideration, and also the neighbors' concerns, corresponding concerns. Ms. Fields mentioned that the 4 exceptions we're requesting are a lot of exceptions. While I understand that, I would take a broader view, and I think if you parcel out the individual subsections, we have potentially 15 to 20 possible exceptions an applicant could request here. And as stated in the staff report, we're requesting 4. I would also propose that while the neighbors may disagree, they are among the less significant exceptions requested. We're not seeking to run bulldozers. We're not seeking to use hazardous substances or conditions that I would argue are incredibly disruptive to a neighborhood. The exceptions we're requesting are, as stated, number of cars coming in and out, number of employees accessing the property, number of vehicles. Noise isn't even an exception we're requesting, but acknowledge that that is a concern for the neighbors. I would propose that conditions of approval, as opposed to an outright denial, are issued. We are more than willing to cooperate and modify operations. Running through the exceptions, noise, for example, the mowers coming from the golf club, the semi trucks down Airport Road, those I would argue are all much more disruptive than what goes on at the property. Regardless, we are required to comply with the guidelines. And we will, and we seek to, but I would argue that there's quite a bit of noise and disruption already in the area. I was down there recently, intentionally at rush hour, and it was incredibly quiet. I found no congestion on the roads. The property was organized, well run. The employees moved about quietly. There was a forklift running, and I paid specific attention to it and found it no louder than a lawnmower. But the noise concern, we are more than happy to submit to a noise study, which is what I would argue is the appropriate approach here. Instead of denying the application outright, let's make it an objective standard and determine whether the noise actually is in excess of the permitted decibel level and give the company an opportunity to comply there. We're also happy to submit to a traffic study. Again, I have not noticed any increased congestion or traffic concerns. It was completely wide open when I was down there. Obviously, I'm not down there every day, but I think a traffic study is highly reasonable. The neighbors' concern about general disruption to the environment, the neighborhood, their property values. Again, I sympathize. but I haven't found the evidence supporting that. The screening up on Airport Road was intended to help the neighbors, was intended to screen off what they found disruptive or bothersome. It was not intended to hide anything. There's no subversive intent here. We're trying to follow the correct procedures and come into compliance. I did find some Google Maps, Street View, and satellite imagery indicating that trash and debris buildup really started in 2017. When the Weibergs purchased the property, they removed about $20,000 worth of trash and debris. They removed an illegal single wide. They removed an illegal septic system. The house was not permitted at the time. Now, there is certainly some outdoor storage that needs to be addressed and reorganized, which we're happy to do, but there's no trash and debris. The residence is properly permitted now and significantly underway. I saw it recently and it's actively underway. We've been approved for a brand new septic system.
Let me ask a clarifying question. You said
Sure.
remove $20,000 worth of stuff. You mean actually they paid $20,000 in removal and waste management fees is what you really mean?
Correct.
Can I jump in here?
Please.
When we bought this piece of property, it was pretty much left neglected from the previous owners, and they let homeless move onto the property, and then in reference, we had to take out about $20,000 worth of pure garbage, I think we trapped, I think, a little over 500 rats that were living just in the garbage and all the debris. And so it's like we have been doing our due diligence just to clean up the property. It's 20 acres, so it takes time. We had 2 stories worth of blackberry bushes that we're still fighting on a day-to-day basis. So it's like we're really trying to move forward. And when COVID hit, it really set us back.
Thank you, sir. So let me just repeat to clarify. You said $20,000 worth, but you mean you paid $20,000 for waste disposal. You said 500 rats?
Yes.
Wow. Okay, I just wanted to make sure. That's a lot of rats. And
Tell me about it.
Yeah. Okay. Thank you. Ms. Mathenia.
Thank you, Christopher. Just wrapping up that statement that we have a brand new septic system permitted, approved, and installed, whereas the previous system was illegal and not approved. I would also submit that there were a number of other ways we could have attempted to handle this sort of business approval. Mr. Cox, I read through Jacobs versus Clackamas County, which is a land use board of appeal case, and the homeowner was attempting to sort of artificially segment their business and apply for a conditional use permit on one side and a home occupation for another, separating uses, separating exceptions to try to force it through the system. So I just do want to highlight that we are trying to do this the right way. The Weibergs really do care. We walked around the perimeter of the property and I noted how far the noise was from the property lines, where the blackberry bushes were, sort of general. I drove all the way around on Prairie View. I really couldn't see any of the outdoor storage from the neighbors' properties. That doesn't mean it doesn't need to be sort of reorganized and addressed, but I really saw no disruption from the exterior. So again, not debating the neighbors' concerns. We are genuinely willing and happy to cooperate, comply. We just request that the conditions of approval be based on objective standards and standards which we can meet and achieve and that can be demonstrated objectively.
Thank you.
Thank you.
And you cited Jacobs. Okay. At this time, did Mr. Weiberg have something further to add, or I know you were represented by your attorney, but you were the applicant.
Yes, I just would like to make a few statements. I just want to thank everyone for participating today. And I know it seems at times that we can be disturbing the neighborhood because I like to live in a peaceful neighborhood also. We bought this piece of property to turn it into a family home. That was our goal. When it came on the market, we chose to buy it because it was a wonderful area. It truly was. And then when we were speaking with the previous owners, they had multiple offers for this piece of property, and they accepted our offer because we chose not to develop it. I think she had 4 other offers, which were a better deal for her, a little bit more money. But we chose to buy this piece of property. It has taken us a while to get to this stage to clean it up. We're fighting blackberries every day. I think they used to grow blackberries here for wine. But when people make statements that we have no intentions of living here, and yes, I do. It's like COVID hit and it put us back a couple of years, just financially and the plan to move here. But now that we're on a rolling path forward, and we're in the middle of remodeling the house, and we're hoping to be done with the remodel in about 12 months-ish. But whether there's a business here or not, there's still going to be noise factors. You know, it's almost 20 acres. Things have to be mowed and maintained. We barely make that much noise during the day. Sometimes after work, I'm out there mowing because it needs to happen. You know, it has nothing to do with the business just because I'm running a tractor. We really like the area. We've really done our due diligence. We've planted a screen hedge to try to just give a little bit more barrier to the property. I know there has been a lot of complaints that maybe we were spraying too close to a lady's well, but you know, we're trying to maintain. And when she made those complaints, you know, we would just weed whack. You know, we weren't spraying around her well that was right next to the fence line, even though in our right, I think we have the right to spray, right? You know, we had the opportunity to put a septic system. The code is a septic system and a well have to be 100 feet. We decided to move the septic system on the a different side of the property, so it wasn't going to interfere with somebody's well, even though we were in the code. So we are trying to do our due diligence to clean up the piece of property. It's a behemoth, and we're fighting every day to keep it clean and keep organized. And we're just running a small family-run business here. And I think sometimes we're working on the property, but it's getting classified as a business. It's all business activity. The business is only ran pretty much out of this barn. Everything else, so just say it's 20 acres, a half an acre, maybe a quarter acre is only business. The rest of it, I have to maintain. It's like the whole business isn't over the entire property.
Thank you, Sarah.
Mr. Cook, that just reminded me of one last sentence. I thought this was noteworthy. Christopher mentioned when I was visiting the property that they've removed the backup alarms from any equipment. And I thought that was a really good example of one demonstrated way that they are trying to find ways to cooperate. The backup alarms bothered the neighbors, so they've removed those. So one less beep going on. Just one of several examples where we are more than happy to meet in the middle.
Thank you for the comment about that. I think we all know what a backup alarm on a moving construction vehicle. You're talking about like the forklift you referenced. Okay, thank you. Yes, Ms. Fields.
You are correct, Hearings Officer Cox. Idling is not exempt from the noise.
Okay. My interpretation of that has always been that it's just the vehicles coming onto the property or leaving the property, but not actually it's not okay to just let a vehicle idle, and that noise is not exempt.
You are correct.
Okay, good.
I would have one question for the applicant. Are you also requesting an exception to the limit on outdoor storage and display? 82204F is storage and display, and level 2s are not allowed to have outside storage?
No, we are not asking for the exception. We're actually getting everything put away and organized. That was part of what we're doing. So there won't be any outside storage.
Thank you.
And to clarify with Ms. Fields, the county's position about storage itself is that indoor storage counts towards the storage of the accessory use of the structure associated with a home occupation. So, for example, if I were to approve, let's say, call it roughly 3,000 square foot of accessory storage space, then all of the accessory use of the home occupation use of an accessory structure. I think I got it right that time. If I approve 3,000 square feet of such use, that any storage use would be part of that approved.
Any storage use associated with the home occupation. Yes.
All counts. All right. Just wanted to clarify. Okay. At this time, I would like to invite members of the general public to provide comments for me to consider in this process of reviewing this application.
I have one hand up. Ken?
All right. So the process will be, I'm going to ask that each member of the general public that provides testimony or commentary today for me to consider in my review of this application, provide their full names. So I'm going to ask that Ken provide his last name as well, and also state your address for the record. Ken, go ahead. I don't hear you, sir. I think that Ken may be muted on his end. No?
He's not muted. We're just not getting any audio.
All right. Let's give it another minute or two.
I have another hand up now. I have
Okay.
David Gellos.
I'm going to cross Ken off for now, and if he sorts it out, then he's welcome to use the raise hand feature and have an opportunity to join us. Let's proceed with the next one.
Good morning. Can you hear me?
Yes, sir.
Okay, good. My name is David Gellos, 14850 Northeast Longview Circle. And appreciate the testimony and the clarifications offered this morning by both the county and the applicant. I have a question, and perhaps Joy, you could help me with this or help us with this, is in the area calculation that's been provided in the determination of the red outlines on the floor plan, is the interstitial space that connects to these offices part of the calculation as well, in addition to any storage area that would be required to have the home occupation operate?
Yes. Areas that are required to be passed through, like the hallways, that employees would be using would be space that is being used by the home occupation. And so that would be part of the calculation.
Okay, and so then just for clarification, because when I had looked at the plan, the floor plan, the red lines did not pop up for me. So I knew they were probably there, but I just could not access the certain layer. So the exhibit that you showed earlier as part of your presentation, the red outlines, does that constitute the entirety of what the applicant is requesting? And then it would have to be reconsidered to include the interstitial spaces in circulation, bathroom, that all those sorts of activities as well?
The application indicated that the areas outlined in red were the areas proposed for the home occupation.
Okay, thank you. The other comment I had, and it's really more or less a question, relates to the exhibit that says septic design. And my understanding is that's preliminary, which is fine. But I'm particularly concerned about the notes in the upper right-hand corner of that exhibit. I don't have the page number for you, but it's the septic design that's titled in red color. Up in the upper right portion of that exhibit, toward the bottom of the text, it indicates that there's a proposed design for the 4-bedroom home and 25 employees in office full-time, 8 to 15, which aligns with the narrative of the applicant. But then the very bottom line says in the office occasionally 25 people or employees. And I'm just concerned about the design of the septic system would need to meet that, I guess is my understanding from the professional outfit that produced this. And then how that would impact the trip generation that we've talked earlier about, or that you mentioned earlier with the limits set forth under exceptions for no more parking than 5 vehicles initially. And then if it's up to 25 folks occasionally, as what this exhibit suggests, that would be, I guess, 40 to 50 trips per day, or occasionally, I should say, not per day, sorry. Anyway, if someone could comment on that too, I would appreciate that.
Ms. Fields, you reviewed the application. Would you like to address it or refer it to Mr. Weiberg?
I would refer it to the applicant because I also would like clarity on the total number of trips, including deliveries that are anticipated.
Okay. Mr. Weiberg or Ms. Mathenia?
I believe that was on the engineering side for just engineering the septic system. I don't know why it says 25 employees. Maybe that's just what he did or standard. I'm not for sure, but I know it's not going to be any more than 15 on an average.
I think the consultant who came out to do the septic design established that this design would manage the capacity for those numbers presented. Whether we'll have that number, obviously we will not have that many. We will be restricted to what the county approves, but the septic system is designed to handle that volume. And one comment on the arrangement of the in-office space, the home occupation space. You know, one benefit of the applicant being a construction company and knowledgeable, moving non-load bearing walls and rearranging the interior space to be compliant is really quite simple. Not for me, I won't be doing it personally, but they can manage that sort of rearrangement quite easily. So whether there's a staircase or an office that appears to not have an exit, that's sort of quite manageable for them.
Okay. You're saying that the interior spaces that the home occupation would require the use of can be moved, rearranged, and reconfigured.
Yes.
Including a stairwell that is on the bottom floors designated home occupation use area that leads directly to the second story home occupation use.
I haven't discussed that with Christopher specifically, but every time we've discussed in general the restrictions that will be put on the space, their response is, you know, we will work within what's allowed. If X space needs to be dedicated to tool storage and can no longer house flex space that's a kind of a desk where somebody can just come in and check email, they're adaptable. They'll work with what they're given. So as long as it's non-load bearing, my understanding is that they can rearrange quite well.
And I want to address a comment that was made by Mr. Weiberg about the employees. He stated on average 15 employees. And my interpretation of employees means a total that's on site. So not an average of 15, but if I were to approve up to 15 employees, that would be the limit. It doesn't need to be the same employees. For example, you can have a different crew on certain days than other days, but it would be a maximum, including the operator that is on, and that would be user on site at any time.
I misspoke when I said average.
I just wanted to catch that before it was gone because we're in the moment. Mr. Gelos, I see that your hand is, and did I pronounce your name correctly, sir? Your hand is up again.
Oh, I'm sorry. I mean to sign out here or move on.
Thank you, sir. Let's give another member of the public an opportunity to participate in the hearing process.
I'm going to try bringing Ken back over.
Okay. And Ken, now it does show that you're muted. If you're unable to resolve the technical issue, I would encourage you to submit a written statement. And I will, before closing the hearing today, provide an opportunity to discuss keeping the record open for additional time. However, in any case, the record will stay open until 4 p.m. today at a minimum. So if you're unable to resolve the audio issue, you still have an opportunity to participate by submitting that written statement. Okay.
I have Ginger Bennett.
Right.
Two things, just for help for those who haven't done Zoom before. The ability to raise your hand doesn't necessarily show up unless you move your cursor over the lower part of the screen there where you currently show up. So some folks may not be seeing the hand button. Also, I've sold real estate, a lot of country property over the years.
Please state your whole name for the record and your address, please.
Okay, it's Ginger Bennett, and I'm at 25108 Northeast Prairie View Drive. And over the years, I've sold real estate and been involved or aware of a lot of these home occupation permits. I've also been active in several CPO groups. And what I typically see approved are exceptions that are much smaller than this. So these exceptions seem to be excessive for what has been, what I've seen happen in the past. So I would ask that we enforce those hard-earned land use laws as they are written. And it seems like this is more of an industrial operation. You drive by and you see the number of vehicles, the amount of storage, et cetera, and it appears to be an operation that should be in a different zoning. And the exceptions that are asking for are way in excess of what I have seen approved before. So it seems that if the county is going to be consistent, this would be not approved.
Thank you for your comments and participation in this hearing.
Mm-hmm.
I have Andrew Tershart. Andrew disappeared. I have Ken again. Okay, I have Andrew Tishart again.
All right.
Can you hear me?
Yes, sir.
Great, thank you very much. I just had to allow audio, so thank you for your patience. And I appreciate the opportunity to speak and the testimony provided by both the county staff and by the applicant and the attorney. My name is Andrew Shearhart. I am at 14585 Northeast Mulligan Court, and I'm here with my wife, Veronica. And what we wanted to speak about was a couple of things that Ms. Fields noted in her presentation. So one thing was the second driveway that had been installed by the applicant. And then also I realized this is not specific to this application, but there was a reference to a previous hearing of code violations, and I do not know exactly the outcome of that hearing. But my concern is that if the county and if the hearings officer were to approve this application with exceptions and with conditions, as a neighbor, my concern is how do I have the comfort that those conditions will be met, given that it appears, if I understood what has been shown today, that certain things have already been done that were not approved at the time, such as this driveway that is going to have to be removed. So any conditions levied as a part of approval really are only as effective as the applicant's willingness to follow those conditions. And so I exhort the county to carefully consider what has been done to the property to date, what sorts of permissions were granted, what sorts of activities have taken place on the property to date that did not receive permits or that were not permitted, because again, those conditions, as I see it as a concerned neighbor, are only as effective as you know, as they will be honored. So I appreciate the opportunity to testify. So thank you very much.
Thank you, sir, and appreciate your citizenship as well. Do we have
Is it
another?
appropriate for me to respond? Maybe address those? Or
Why
if it's
don't
neighbor only?
let's wait till a little bit closer to the end. I think I do
Okay.
see that I kind of set a precedent of responding in more time, but I think there may be more members of the general public that have similar concerns.
Sounds good.
I received at least well more than a dozen similar written comments.
The only hand I have up now is Ken.
I think we can give Ken another chance. Not everyone is as familiar with joining a online hearing as the people who are here today. So let's try. I don't think that's Ken. He's muted. Let's and again, I gave Ken some direction on how to participate today. So Ms. Mathenia, go ahead with your rebuttal.
I'm sorry, Mr. Cox. I have several more hands that just went
Oh,
up.
oh, okay. We have more hands. I apologize, Ms. Mathenia. Let's wait again.
I have Laser.
Yes, this is Laser. My name is Lloyd Johnson, and I'm sitting here with Ken. Can you hear me?
Yes, sir.
Okay, so I'm just going to let Ken talk to you on my phone.
Okay.
Hello, this is Ken Ivy, and I am the chair of the Aurora Butteville Barlow CPO, and we did submit written testimony,
Yes.
and I wanted to add a few things. Oh, by the way, I'm sorry, my address is 24780 Northeast Prairie View Drive, Aurora 97002.
Thank you, sir.
And like you, I would have loved to have chimed in every now and then, but so I made a few notes because when I looked at the building that they have in the red areas, I added up much more than 3,000 square feet. And I noticed that they had not put red around the bathroom. So it seems that their square footage doesn't include a bathroom for the employees. Also on page 5, the outside storage, page 5 of the presentation by Ms. Fields shows a great deal of storage outside and is not allowed. The comment or the reference she made to level 3 is because if you have a level 2 home occupation and you ask for exceptions, the code says that it will be reviewed as a level 3. Therefore, the fact that there are no, or that the, well, in fact, they have no adjoining or abutting properties that are 2 acres or more. Everything is below, there is one above 1 acre and the rest are below 1 acre. So from that standpoint, it also does not qualify from there. So they have several other, exceptions that they're asking for that aren't on the list. The noise talked about is they have the backup alarms on the cars, but they also, according to the forwarding letter that their attorney sent in, they start at 6 a.m. So the noise starts at 6 a.m. Code says you can't start before 8. And you're getting backup trucks at that hour. And I'm not real sympathetic that they haven't started on the house in 5 years. COVID's a long time ago. They managed to work on the barn constantly, but they put nothing into the house until it was pointed out to them that the number one regulation is they have to live in the house, and that can't be waived. Then they put in for an application to work on the house and to get the septic right, which also means they've been on that property 5 years with 15 plus people and no septic, or at least not a functioning septic. So those are kind of the things that I noticed, along with, if you look on the internet, this is said to be a minority owned business, that the principal shareholder is Joyce Weiberg, and that she is running day-to-day operations in order to qualify as a minority business. That means she would need to live on the property as her principal residence. As I say, this month actually is the 5th anniversary of the first complaint on this property. And, they bought the property to use for industrial, it's residential, and they immediately started changing it over. It quickly became a nuisance. They went about a major change to the barn without requesting a permit. It was only after complaints that they were visited by the county and they were caught and they had to file a permit. And the permit says that the changes to the barn were personal. And regardless of the complaints and the rest of it, they have run that business on whatever days and whatever hours they care to. The code for home occupation, it really, if somebody follows them, they'll blend peacefully into the neighborhood. It's principally supposed to be run within the home and then maybe into the adjacent building. This is a major construction company. And I can't imagine that it won't grow, which means next year they'll have to ask for 20 people and the year after that and so forth. This belongs on industrial land and nowhere near a neighborhood and not in a rural reserve. We asked that the permit be denied, the application be denied, and we asked that there are no compromise and no promises to scale back. Their lack of regard for the neighbors and the county code for the last 5 years shows that they can't be trusted to comply with anything short of vacating the property. So that's our ask.
Thank you, sir. Thank you for your comments and participation in this hearing this morning. Are there other, and I will certainly consider them just as I will consider all of the comments I've received. Do we have another member of the general public?
Sorry about.
I have Greg Leo.
It says Greg Leo on behalf of someone else. You're muted still. There's usually an audio.
I'm asking him to unmute, but there's no response.
Okay, let's move on.
I have melissa.bessie@sortis.com.
Okay.
Can you guys hear me?
Yes, good morning.
Good morning. My name is Melissa Bessie, 14545 Northeast Mulligan Court. I get really emotional about this, so I'm not going to say very much, but I just wanted to echo what Ken said. Our property is right behind this warehouse, and it's not a hay barn anymore. And it is loud, and it has been so disruptive over the last 5 years. We moved in 5 years ago, and I wish I hadn't bought this property because we didn't know. We thought it was a farm property behind us. And just this morning, we woke up to there weren't any backup sirens, as there often are, but we could hear, activity going on, vehicles driving in and out. I was over there last year, and they did say they were going to clean up the outside stuff, but there was quite a lot of very large attachments that go on things like forklifts that there's no possible way they would be able to fit inside that building. There was maybe, I wish I'd taken a picture or something, there's maybe 20 of them, these really large, heavy equipment attachments. And other things. I've written a letter, and I will follow up with a letter again this afternoon because, like I said, I get a little bit too emotional to talk about this. But my husband and I, our family, would like to request that you deny this application, that you ask them to cease all business activity, and that we can continue to enjoy the rural residential lifestyle that we moved here for. Thank you.
Thank you, and I will certainly consider your testimony and the written statements that you are submitting.
It looks like that's all.
Okay. I would like to, or I am providing an opportunity for the applicant to provide some rebuttal or explanation, something that you want me to consider in addition to the subsequent to the comments I received from the general public. I think you're muted. It didn't look like you were muted, but I wasn't receiving any audio. You're muted on your end now. There. Nope. You want to try coming back in? Okay. Or Darcy, do you have a,
Yeah, if she wants to leave the meeting and then rejoin, and I'll watch in the audience and make sure she gets moved back over.
okay, let's do that. Now,
You could try calling in.
do you have a cell phone? You could call into it while you're on video through the no audio channel. There's a phone link. Technology is great, except for when it really isn't. That's my standard tagline on this.
Can you hear me now?
Yes.
I'm so sorry, nothing changed on my end, yet everything changed.
Enter your participant ID.
Okay.
Okay, I was saying, Mr. Sherhart, those were good questions, and I appreciate you reminding me of something else I wanted to add. The engineering report that the city prepared and submitted as testimony did confirm that the site has adequate capacity to serve the home occupation exception, and you are correct that the southern driveway is to be removed. I was down there recently and they are not using that driveway. So I wanted to reassure you that yes, that is correct and to be removed. I will leave your question about enforcement up to the county. And then Mr. Ivy and Miss Busey's questions and concerns about the noise, I have asked the owners multiple times whether there's any noise going on at 6 a.m. and I hear it's just employees arriving, maybe a car door, a business door opening, which is allowed, and that no noise starts before 8 a.m. And that's something we would certainly be held accountable for and are willing to comply with. We're happy to do a noise study to confirm that. Christopher also confirmed to me that many employees leave by 3 or 3:30. So evenings and weekends should be rural in nature. No, aside from the lawnmower that would run on any 20-acre property. So our request would be that the appropriate remedy is not an outright denial, but establishment of conditions that this use is permitted in the area, but within certain guidelines, and we would have to follow the rules, but conditions of approval as opposed to an outright denial is the appropriate response, I would say.
Let me just clarify one of the things you said. I follow and I try to take good notes, and I'll review what you said. But one of the comments you said, no weekends. Does the business not operate on the weekends?
Correct. I imagine there's every once in a while something that needs to be done, but they operate on a 5-day work week, just like any standard business.
No, the business does not operate on the weekends. That if there's noise over here, it's probably me or one of my family members mowing or trying to clean up something, to be honest with you.
Okay.
On the 20 acres.
Okay.
And the other comments that the operator is not living in the house and that this is a major construction company, that's correct. And we have not tried to hide that fact. The major construction portion of the company, though, takes place off-site. They are demoing, they are constructing, they are doing commercial work off-site. So that is true, but not on the site. And Mr. Weiberg has a residence elsewhere. So that has not been his top priority. His top priority was to keep the business afloat, get that going, and he is now simultaneously working on the residence to move in. So wanted to confirm that both of those are accurate statements, and we agree and understand, and it's part of the proposed remedy.
Thank you. At this time, I would like to talk about an open record period. So I'm going to read the statement that's required. Does any party or member of the audience want an opportunity to provide additional evidence, arguments, or testimony? Does the applicant wish to waive the period for final written argument? So let's talk first about the first sentence. Does any party or member of the audience want an opportunity to provide additional arguments or testimony? Okay. Then secondly, if there is no request to keep the record open past 4 p.m. today, does the applicant wish to waive the period for final written argument? Meaning you have an opportunity that is yours to provide written rebuttal, written things that address issues that were discussed, evidence that was discussed, the testimony or commentary that was made, the staff report. You can do that in writing as a rebuttal. I don't want to see new evidence, because that would be the first period to submit new evidence. However, the applicant gets that final written argument period, unless you want to waive it.
Christopher, I don't have anything further to add.
How long would this period be open? Because I would like to, there's a lot to process that has gone on today, and so I'm assuming over the next hour or two, and I get some more my thoughts in order, and just everyone's.
And there could be new public comments submitted by 4 p.m. today as well. Mm-hmm. So I'm not going to require that you make a decision right now. I don't really like putting people on the hot seat. What I am going to ask is that so you did not waive, is what I'm understanding, the period for a final written argument at this time. I think under the statute that if the applicant keeps a final written argument period open, that there's a corresponding extension of the timeline from the county to make a final decision in the matter. So I believe that's correct. So what you would correspondingly be asking is for an extension of the timeline here. But you can waive that just by contacting the county, let them know, an email to Ms. Fields is sufficient that you've decided to waive the remaining part of that. And okay. Did I answer that fairly?
Thank you.
Ms. Fields, is that your understanding as well? That if there's a period for final written argument requested by the applicant, that it is not counted towards the days that the county has to process this application.
So you're referring to the 150-day review clock?
Yes. I don't think we're anywhere near coming up against that, though.
We are not concerned with timing on this application. However, if the applicant would like to extend the clock by a week to facilitate your final written argument, that would be fine. Or you can provide me with an email closing the final written argument, and that is up to you. Yes.
Okay. So
Thank
no
you.
hot seat, which is what I really don't want to do, which is require an answer right now. Submit either that final rebuttal, final written, that last word within that period. You also could request and provide substantial reasons for me to consider for extending the record past that, but I don't see any reason at this time to do so. So with that, the materials that were discussed today should make it into the record by 4 p.m. today. The applicant does still have the opportunity to waive that final written argument or any remaining portion of it within the next 7 days. With that, I will close this hearing. Thank you all.
Thank you.
Got it.